Justice isn't just about the law. It's about the people who fight for it. I'm Jennifer Long, CEO of Equitas, where justice isn't a concept, it's a commitment. And this is Just Champions. This season, we're breaking down the most critical court cases shaping the fight against sexual violence, intimate partner violence, stalking, and human trafficking. Each week, we sit down with prosecutors and scholars to break down the decisions that define justice and to discuss the challenges that still remain. Because the law isn't just theory. It's the foundation of real lives, real cases, and real change. Hi, everyone. Welcome back to Just Champions. I'm so excited to be here with you all today because I'm sitting with Yiota Souras, Senior Vice President and General Counsel for the National Center for Missing and Exploited Children, NCMEC. So just larger-than-life champion. And she provides legal guidance on matters relating to finding missing children, reducing child sexual exploitation, preventing child victimization. And she works across criminal and civil issues that relate to online child sexual exploitation and technology companies. She also oversees federal and state legislative matters. She's testified before Congress. She's a frequent panel speaker on these issues, also including child sex trafficking. And she has her BA in history from Johns Hopkins and a JD from Fordham University School of Law. Yiota, you're our first non-prosecutor on for this season. So hello and welcome.
Thank you so much. Thank you for including me and for including NCMEC on this issue.
Absolutely. And there's so much to talk about. So I think the first thing I just want to acknowledge is that you will be back because there's a lot to talk about. And I do want to just set the stage here, I guess. The caveat I already gave that you're going to be back, and a summary, because we're going to be talking about child exploitation today, and that is a very big term. It's a term to talk about a lot of horrific things that happen to children. And I also just want to remind people, and Yiota, correct me if I'm wrong, that children, we're talking about everything from infants up to 17 years old as our victims. A lot of our victims, sexually exploited women and human trafficking victims have talked about this magic number 18 because it seems like an artificial line a lot of times between children and adults. And you're working at an organization that's been fighting this for, if my math is right, definitely over 40 years, maybe 41, coming up on 42 years. So you've learned a lot. And a lot of what we're going to talk about today, the issue of child exploitation and child sexual exploitation is so huge and so important. One of the things we're going to hone in on today is to really talk about how your efforts to identify victims and identify these crimes of exploitation, your efforts to help investigators and prosecutors really counter these crimes and fight them and find these perpetrators, these abusers, and hold them accountable. And then your efforts to prevent exploitation, especially that online, the things that you've learned that, from the work when we're working with adult victims, which is something that Equitas's majority of the focus is on. How do we learn from you? And how do we learn from, everything from the impact on victims all the way through to the strategies? And so I wanted to start with that because I want to make sure that people know this is in no way trying to prioritize one victim over another, just the focus of this piece. But one thing I've really always admired about you and really loved when we've talked is about how you center victims. And I think I really do want to start by talking about child sexual exploitation and its impact on victims from your experience.
Absolutely. Jennifer, thank you. And that is really a core component of how NCMEC views all of its work, whether it is in our Missing Children Division or our Exploited Children Division. Our mission is to help the child. There may be a criminal action afterwards. There may be a restitution action afterwards. There is always one or more offenders who are involved in those crimes. But our goal is really to find the child, to help the recovery of the child, and then to be there after the recovery as well, to help reunite the child, to help them with the services that they may need going forward so that they can have a full and complete life after their victimization. So it is something that certainly is very core to our operational divisions and to our case managers and analysts when they are working on cases and reports that are coming in. And it certainly comes through in how we center our policy and our legislative work as well.
And I know this is probably less so in the child arena, but I still, just in various conversations, sometimes it's, careless remarks from people. Some people may think, okay, if a child is so young and there's no quote unquote physical injury, is the harm of sexual violence, is that somehow less traumatic? Let's just say, not that it's not harmful. And or when we're talking about online abuse, is this somehow less harmful to a child or to a victim? And so I wondered if you could talk about first the harm of exploitation on victims. And next, then in that conversation, talk about how the role that online abuse and image-based abuse plays across physical and sexual contact crimes, penetrative crimes, as it impacts victims.
Absolutely. It's a big issue and a big question. So certainly from NCMEC's view, the sexual exploitation of a child oftentimes does begin with a hands-on offense. Somebody has raped or sexually abused a child. They have taken videos or images. They may keep those images or videos for themselves or share them in a closed circle. They may put them on the internet, and those images may go global. They may be circulated among offenders, thousands, tens of thousands, hundreds of thousands of offenders, traded and retraded, even long after a child has been recovered. So in those types of cases, of course, there is the direct physical harm to the child, the emotional impact of that actual abuse. And then what we see is the trauma and impact afterwards, the child's knowledge and awareness that those images continue to be recirculated, shared. There is the impact on the victim, the fear that creates, that somebody may be looking at their photos, somebody may be using those photos to groom another child. That's a concern we hear quite often from victims and survivors. Just the knowledge that those images could come up on the internet really at any time, any place, even as they age out of being a minor, surpass the age of 18, they're in their 20s and 30s, they have careers, they have families, they have their adult life. The knowledge that those images are still out there does create this recurring and ongoing trauma that they need to continue to work through. And we have a wonderful group here at NCMEC that really focuses on working with survivors, through many of those incidents, working with their attorneys to try to provide guidance as well as therapeutic support. One thing I'd like to note, if I can, when we talk about child sexual exploitation, there certainly is the image-based exploitation, what we refer to as child sexual abuse material, or CSAM, which is known under the law still as child pornography. Hopefully we will see that terminology change one day soon. But we refer to CSAM, as do most prosecutors and nonprofits, referring to the actual imagery. But there also is non-image abuse. There is sextortion and enticement. There is abuse where images might be taken but not necessarily circulated widely. So I just want to acknowledge that there are many types of survivors and victims of child sexual abuse. They often are not always victims of the distribution of CSAM online.
You talked about how abusers can use these images to groom, and by grooming children, talking about breaking down barriers to sexual activity, trying to normalize it. How do you see, or have you seen, perpetrators use these images to proliferate abuse among offenders, sort of bring offenders in to increase abuse, to help them identify victims? Can you talk a little bit about how these images are used on the offender side, by offenders, for offenders?
Absolutely. When we talk about CSAM, or these images being used to normalize, it is certainly both as to the potential victim to, again, groom or make them feel like this is something a child should engage in certain circumstances. But the normalization also goes outwards towards society and towards offenders who might be like-minded, but perhaps have not really entered that world where they are creating imagery or collecting it, but the availability of it, the knowledge that it's on the internet, right? We say that about virtually everything. I saw it on the internet. It must be okay. It must be something other people are doing. There must be thousands of people around the world that have this interest, so I am not as isolated anymore. My feelings of wanting to offend, of wanting to commit these crimes, are normalized because now I have a community. I have this community online where everybody is doing this. Some have done it for years and decades. So that is a really dangerous aspect as well when we talk about these images going online and the proliferation of these images online.
Now, you talked a little bit about in the beginning of NCMEC and its role in addressing these crimes and identifying victims. I know you work a lot with law enforcement and prosecutors. Can you talk a little bit about what you've learned over time about how best to identify these images and investigative steps when you're dealing with child sexual abuse material?
Absolutely. So NCMEC is a nonprofit organization, so we don't investigate ourselves, but our goal certainly, again, is to focus in on the child and the child's well-being and also try to provide as much support as we can to law enforcement prosecutors, private attorneys that might be there to help the child. I think what we've learned is that these crimes change. They change over years. They change over decades. Technology and technological advances has a tremendous impact, certainly for the world when we see new technology emerge or you see technology become more ubiquitous, more commonplace, cheaper for the average person to have. We see those impacts on the crimes against children as well online. We often say offenders are often early adopters of new technology. I think, unfortunately, that's the case. So as we see, storage get cheaper, so people can have larger cloud accounts, we see larger collections of images, larger collections of CSAM being collected. When we see the ability to anonymize online, whether that's end-to-end encryption or a VPN or something of that sort, again, we see offenders using that to try to obfuscate their actual geographic location. When we see multiple platforms, chat, as well as photo distribution or photo sharing apps, we see offenders get, very savvy with enticing a child on one platform and then moving them to another to actually exchange imagery or entice that child to create imagery and send it to them. So this has always been the case historically. So our goal is to keep an eye on the technology, understand how it's impacting the crimes, try to educate, try to be, because we do operate the cyber tip line. What we see from operating the cyber tip line, which is a congressionally designated platform to receive reports both from members of the public as well as online platforms, which basically is all the social media companies and other online companies, we receive reports related to child sexual exploitation. So that may be child sex trafficking, that may be CSAM, that may be enticement, sextortion, as well as other sexual crimes against children. The receipt of those reports, last year over 20 million total reports, almost 30 million incidents of child sexual exploitation captured within those reports. The data from those reports allows us to identify trends. So we are often able to be the first out there to say, something is happening here. There is a change in how offenders are victimizing children. There is a change in how offenders are utilizing technology, different platforms they may be on. So one of our goals, of course, is to address the problem as it comes in from an operational basis, but also to try to look ahead, really as a kind of first alert system to see what is happening next. What will the next change be?
So you brought us right in because before we talk about how the law has to change, has evolved over decades, much more than 50 years to deal with child sexual abuse material, talking about technological changes, looking at AI-generated images and deepfake. And I wonder if you could just take a moment, again, you never quite know who's listening and what their background is. If you can just define a little bit of what we're talking about when we're talking about AI-generated images of child sexual abuse material, and then talk a little bit about that impact on harm to victims.
Absolutely. So artificial intelligence has been around for many decades. Every time you go to a website and something comes up and says, how can I help you? Or can I help you navigate this site? That's just artificial intelligence. So we're all very used to that. But, what we started to see, and I think become more of the public consciousness, once we hit 2001, 2002, was discussions around generative artificial intelligence. So tools that were able to not just help direct you and sort of converse with you on a very basic level, but tools that were able, and technology that was really able to craft text or to craft imagery based on a user prompt. So instead of just saying, take me to the sweater section on this website so that I can shop, you could say, I want to see a sweater. I want it to look like this. I want it to have buttons. I want it to be this color. Now I want you to change it again. And it could actually respond to you and respond to your prompts and help you create, again, text or imagery. So NCMEC really started to become aware of generative artificial intelligence, or GAI, as it's more commonly referred to, I would say in 2022 or so as an issue that could impact us, certainly, given how good, how sophisticated the technology was becoming, and also how utilitarian it was becoming. So you didn't have to be a computer scientist. You didn't have to be working at a university to have access. Suddenly, it started to very quickly drop into just the general population in terms of the tools. So in 2023, we started keeping a close eye on its impact on child sexual exploitation, because our concern, again, is if there is a technology tool that can create what you want to see based on what you write, then that will, again, be adopted by offenders and they will utilize it to abuse children. So in 2023, we were able to detect about 4,700 reports that we refer to as GAI related. There was some indication that a GAI tool had been used to create that content or that offending text. In 2024, that number went up to 67,000 reports. And then in March of this year, in total, we've received well over 100,000 reports. So the numbers are increasing, again, as the technology gets better, as it starts to become ubiquitous, as offenders start to become more and more aware. It's very cheap. It's often free. It's very easy to use, and it's hard to detect. So this is kind of the perfect storm, so to speak, for offenders who want to expand the sorts of imagery that they're creating. So the impact is real. We are seeing these imageries, and we often break it up into 4 types of abuse that we're seeing from GAI in general. So I'll just break that down if that's okay. The first one is really text to text. So something, again, like a chatbot that you're chatting with. It's not creating images, but we have seen reports where offenders are using a GAI chatbot, let's say, to help it find things on the internet. So somebody could ask to find imagery, specific CSAM, specific types of websites where they could find these sorts of images. They also will often ask questions, things like, how do I find a 9-year-old for sex? How do I lure a 12-year-old into having sex with me? And then, we also have seen reports where somebody will say, talk to me like you're a 6-year-old who wants to have sex with me, so that they can have a back and forth dialogue. So these are just examples, text to text, how that can be used. There is, of course, text to image. So again, far from the innocent sweater example that I referred to earlier, somebody saying very graphically and specifically a sort of child sexual abuse image that they want to see. That certainly is created by positive prompts, saying, I want to see a 6-year-old, I want them to be positioned this way, I want them to be in this sort of setting, and then also by negative prompts. So I don't want them to be over 13. I don't want there to be anyone else in the photo, whatever else might be relevant to what they want to see. So we see those instances of abuse as well. And offenders, again, get increasingly savvy and also will trade tips online about how to kind of jailbreak or work around certain safety parameters that might exist in those particular chatbots. Then another type that we see as well is text to text. So I may have an image, just an actual innocent image. I may have taken it off social media, maybe an image I have of my possession. I can put that image in, and now I can alter it. So I can put an image in of just a child standing outside. I can change the background to a bedroom. I can ask the image creation to remove certain aspects of clothing, enhance the child's body in some way. I can go through all of those prompts as well. And then, the last I would add, because it's a slightly different category, is the nudify apps. So we've seen, I think, a lot of media attention to those types of apps. Again, very ubiquitous, very easy to find online. And they allow you to submit a photo and then simply nudify the photo. So we've seen this certainly happening with politicians and movie stars. We've also seen a large number of media reports and are very familiar at NCMEC with a number of cases involving school children, so middle and high schoolers, again, because the technology is so easy to access. Unfortunately, typically boys in these schools creating these images of girls and then trading them online amongst each other. So I'll kind of add that as a fourth category. Two particular types that I think are especially virulent, two particular types of the abuse involving GAI. One trend that we've seen also is offenders who already have possession of CSAM images, maybe an image that was taken 10 years ago, but continues to circulate online. Offenders will take that image that has been circulated online and they want to see it different. They want to see it maybe with their bedroom as the setting. They want to see another person in the image. So they will take an image of a child who may now be an adult who has obviously gone through some recovery. And now that image is being changed and recirculated. So it's the creation of new CSAM based on old CSAM. It's a unique type of re-victimization for these survivors who, again, were aware of the original images, knew how many there were and what the circulation was, and now there are new images being created off of that. Another very virulent, type of this abuse that we're seeing is offenders who want to sextort a child, which previously involved them creating a fake persona, usually somebody that the child might be romantically interested in, engaging in kind of an enticement period with them, kind of luring them into sending an explicit image or a nude image of themselves, and then immediately escalating into a sextortion situation where they would say, now that I have this image, I'm going to share it with your users online, with your friends and family. If you don't make more images or images of this type, sometimes that involves a financial component. They may say, you have to send me $300 or else I'll share this in 48 hours, something of that sort. What we see now is GAI enables offenders to skip that whole introductory process. They no longer have to try to lure a child into taking and sending a photo. They no longer have to build that rapport and trust. They can take an image off of that child's social media account, use GAI to make it explicit, and immediately approach the child and say, I have this image and I'm going to circulate it. So again, we see that also as a new trend emerging from GAI.
So what's the harm? Maybe you can answer that question once and for all. What's the harm if the victim in the image is a virtual child or a virtual person?
Absolutely. So the simple answer is that the core harm is that it normalizes this sort of activity, the sexual exploitation of children. It normalizes it to children who might be enticed and groomed by these images, and it normalizes it for society, which might think, it's on the internet so often, I see it everywhere, there must not be any harm to it. And it normalizes it for offenders who are perhaps questioning whether this is illegal or not illegal. It creates this baseline of normalcy around this sort of exploitation, and it makes it ubiquitous. And there is a tremendous danger in that to children, and I would say also for how society views the abuse of children.
And this is the thing. I mean, I'm so glad you took us through this. And for people listening, this is a very methodical and a bit of a longer episode into the incidents. But I think understanding the full scope of child sexual abuse material, adult sexual abuse material, and the spectrum of it, just understanding everything you've talked about is applicable to adults. What tends to not be maybe an additional unique piece that I would say hits probably adolescents, high schoolers, adults, is this victim blaming, this tendency of pointing the finger at maybe what someone did, quote unquote. Did they share something first consensually that was then manipulated? So I feel like from the adult point, we're always fighting that. But for this case, thinking again about the deepfake and thinking about the scope of adult sexual abuse material, when we're thinking about the type of prompts that can come in with adults, because you might start with a nude image, which is exploitive if it's not, for the victim, of course, especially if it's non-consensual. But maybe some of the text prompts now go into violence or rape against this individual. And so I think about what you've learned tracking child sexual abuse material and how it can impact our adult victims. Because our experience so far, and again, you're going to talk about take it down. We're going to talk about the law in just a moment. And I think it's getting better. But I think there's this gap still. I don't think. There is a gap still where we have a victim who has not been identified, or a perpetrator that hasn't been identified, or the crime scene, if you will. So no identifier. And maybe now this question of, is this virtual or is it real? And you have abuse captured in these images against adult victims, and sort of a black hole of where these images go, and how that represents a huge gap in how we're able to protect victims, either victims who might be in the image, who might be currently experiencing abuse and terrible assault, or future victims for whom these images are serving as an enticement and a recruitment for future acts against adult victims. I think about when I am one of the things I think is so fruitful and so generous about what NCMEC has done is that you've taken all of this experience and you willingly, generously share it with all of us working in the field to try to figure out if what you've learned can be adapted to adult crimes. And I wonder if, just before we move into the law, if you have any thoughts, if you can even make sense of my meandering commentary and question.
No, of course. So, I think obviously NCMEC focuses on child-related crimes. There are unique enhancements under the law and unique acknowledgments under the law for a minor who is under 18 and their victimization. But I think many of the things that we see and that we were talking about earlier, the impact on the victim, the humiliation, the harassment, the feeling of hopelessness, the feeling that there's no remedy, the feeling that they can't go to law enforcement, or that somebody will blame them. I think many of those feelings and emotions could easily transfer over to adults. They will often feel the same as a child who is victimized in terms of those components. So I think it's important to acknowledge that sort of harm in general, regardless of if it's a child or an adult.
So, Yiota, as you know, we usually have a case of the day, but in this case, because the statutes and the cases have evolved over the last 50 years or so to handle child sexual abuse material and this emergence of adult sexual abuse material, we're going to do it a little bit differently. And I hate to really over-rely on you and your experience and your knowledge about this. So I'll lay out where I see this, and I'll be honest, one of the statutes, we talked about them, child pornography. I'm not 100% sure where it fits in this exact category, but in terms of the timing of it, and I'm talking about 18 U.S.C. 2256. But I feel like we had that statute, and then we had Ashcroft v. Free Speech that ostensibly, even though it probably wasn't about virtual images, did attach to that. And then from that, maybe the PROTECT Act, which I think the specific name of that, the prosecutorial remedies and other tools to end exploitation of children. And then out of that, coming the statute, 1466A, and then NCMEC, and the way that it went back and looked at some of the early pornography cases, Stanley v. Georgia, and maybe some others dealing with children. So I just wanted to give you the huge universe, but a little bit of the universe path to have you maybe, as briefly as you can, give us the landscape of how this law evolved And now I'll bring us then to the intersection of what the legal issues are that will be decided and how it may impact AI-generated child sexual abuse material and ultimately adult sexual abuse material.
Sure. So I think, Jennifer, this is one of those instances where the history of these laws and the definitions and how they have evolved is going to be tremendously important as we go forward and look at how does GAI or whatever the next technology may be in another 5 or 10 years, how does that further alter or shape how we look at these laws? What are the core judicial impulses behind some of these laws? What was the motivation? I think that the judicial motivation around how some of these definitions have been handled is going to be equally as important, if not more so, than the letter of the law in many instances. So I would really go back to 1973, to the Miller versus California case, which was the first instance where the Supreme Court really was faced with defining what is obscenity. This was in an adult context. But the court had never really grappled with what is obscene sexual content in general. So the court laid out a 3-part test, which, can be difficult to apply in some instances, but really has held more or less through to this day. So the first factor was, would an average person, and again, a lot of subjectivity there, but would an average person seeing the image believe that it appealed to prurient interest in sexual conduct? The second factor is, does the image portray sexual conduct in a patently offensive way? The third factor is there any substantial literary, artistic, scientific, et cetera, value to the image? So the court said, that will guide us to determining if content, and again, adult obscene content in that instance, if that content is illegal. So that was, helpful. It certainly helped guide the courts for the next, I would say, 9 years until we get to 1982 and the New York versus Ferber case. So that was and is still the core case where the Supreme Court discusses what child pornography is and really made a really monumental decision that child pornography needs to be treated very differently from obscenity. So the court held, I'm not going to use the Miller obscenity test here. These are children. These need to be dealt with very differently. The court emphasized that there is a compelling government interest in protecting children from child sexual exploitation, combating that. So that was, I often say Ferber was where the Supreme Court declared child pornography is per se illegal, has no First Amendment protection, it has no other legal protections in any context. And it really said we're taking any obscenity analysis and we're elevating it when it actually is child pornography. So I think exactly 20 years after that, we have the Ashcroft decision that you referenced earlier. Now, there was a lot going on in the Ashcroft decision, but it really was a case that was responsive to a challenge to how Congress had tried to revise the child pornography definition at the time. So child pornography, very generally speaking, is an image of a minor that is depicted engaging in sexually explicit conduct of some sort. Now, there are a couple of other subparts that are relevant here. In the Ashcroft decision, the court was looking at some statutory language, again, that had just been passed that said the image could include a computer-generated image of a child that is a child or appears to be a child or a minor engaged in sexually explicit conduct. And that appears to be was part of the challenge. So the Supreme Court had to reflect on that language and really do a constitutional analysis. And basically they held, we know what we held in Ferber, how child pornography is the most extreme and per se illegal conduct, but saying appears to be a minor is a bit too constitutionally overbroad. So they basically said that cannot be part of the definition. Congress returned the next year with a new statute, revised that statute, corrected it, and included what is now, since that time, has been part of the child pornography definition, and said child pornography, can include a computer-generated image that is indistinguishable from a minor engaging in sexually explicit conduct. Some might feel that's not too different than what was in the statute before, but that has been the language. It really hasn't been changed since that time or robustly challenged in any way. So the Congress was successful in inserting that computer-generated language, again, like you said, long before GAI, but clearly understanding that images were going to be changed and revised as offenders had more access to technology. Morphing is a really earlier example, I think, where using Photoshop or other types of really basic technology tools, offenders were able to mix sexually explicit images of adults with minors. So again, Congress and the Supreme Court wanted to make sure those were illegal. So that's what we saw kind of post-Ashcroft. What Congress also did, though, when they revised the child pornography statute post-Ashcroft, is they created 18 U.S.C. 1466A, which is the obscene visual depiction of a child engaged in sexually explicit conduct. So it's the child obscenity statute, basically. And what they did in that statute is they also criminalized an image of a minor engaging in sexually explicit conduct that is obscene. And specifically, that image does not have to include an actual child. So this could be a rendition, a cartoon, again, some kind of extreme Photoshop of some sort, but there's no requirement that a prosecutor or a court identify a real child if they are going to pursue an obscenity violation. So now we have the child pornography statute, obviously criminalizing images of what I will call real children, actual children who are being victimized and sexually exploited, also criminalizing computer-generated images where the minor is indistinguishable, from a minor, and also images that are altered. So again, kind of the morphing example. But there must be a child, again, or someone indistinguishable from a child. So this is kind of where some of the legal tension might be in that definition. And then we also have the obscenity statute for cases where you do not have to or cannot prove there's a real child, but there is sexually explicit conduct, it is a minor, and it does meet that obscenity test, again, going back to Miller. So these are the two statutes that are primarily used to combat child sexual exploitation today.
So then now we're in a situation where, and I had mentioned Stanley v. Georgia, because I feel like and that had to do with adult material, that adult sexual abuse material, and not even raised by a victim. It was raised by the First Amendment or the protection of someone to have adult sexual content in their possession in their home. And that case was used among other things, was used in or is being used in a recent challenge to look at the whether or not there's a First Amendment right or a privacy right for an individual who has child sexual abuse material that was GAI, and whether or not that person is protected now if there's no evidence that that material was shared. Did I describe that correctly? And can you talk about the legal merits of that case?
No, absolutely. I mean, Stanley has been around since before all the other cases that we just discussed. And as you said, it was a very, very narrow case involving an individual who had adult pornography, possessed it in their home with no evidence of intent to distribute, anything of that sort. So, I think that decision has been rightly read, first of all, to apply only to adult content, and second of all, to apply to this kind of mere possession in the house. Again, not purchasing it, distributing it, sharing it in any way. So again, no interstate commerce, no involvement of any other factors involved except the person and their content in their house. What has happened now, I think, is, looking at that type of decision and trying to perhaps expand it in a way that would also permit the mere possession in the home of GAI CSAM, so child sexual abuse material that has been generated with GAI, under an argument that, somehow that is the same and or causes, no impact, and a reasonable person should just be able to possess that imagery at home if they do not have an intent to share it in any way. It's a tremendous overreach of the Stanley decision. And if I think this is also where you can look at the language of the definitions and the statutes, but I think you always have to go back to Ferber and really look at why has the Supreme Court acknowledged child pornography as being in this kind of uniquely, extremely kind of worst of the worst category of content. And I think it's because, the court recognized, this kind of the oft-cited quote from them, that protecting children and, making sure to combat the sexual exploitation of children is a government objective of surpassing importance. So I think you look back to that sort of quote and that sort of policy directive in many ways from the Supreme Court when you look at some of these GAI cases or some of these GAI discussions that are taking place, when you say, what's the harm? Where's the victim? How could this harm children if adults are just making images and trading them or possessing them in the home? I think you go back and look at the direction the Supreme Court gave us. This is a matter of surpassing importance to protect children from this type of abuse and exploitation. And as we've discussed kind of throughout today's session, GAI CSAM harms children. It leads to their exploitation, and it breaks down the barriers that could protect them from that exploitation.
I mean, I think about, and we had talked about it a little bit. I mean, when we think about the things, this has been discussed in many different ways. I'm gonna actually cite one of my favorite people in the world, my mother, Lorraine Gentile. She had a really direct way of saying things. She used to call things the bikini theory, but it was, people have written about this, that it becomes more and more important to have extreme of something. So nude, whereas before we might have had, women not on the beach. This is going back where you were fully covered to very different evolution of swimwear to now that's not enough really for people who are into pornography. And this is where we see the hardcore pornography and violence and other places directed. So when I think about what people are going to be creating in their home, and we've actually seen this in mainstream video games, when I think of Grand Theft Auto and some of the sideline pieces that have been involved in that game. So when I think about what GAI could be created for an adult audience with adult victims, it's bone chilling. And I do think it definitely can create real harms for individuals out there because of what it can incite or what it can suggest, what it can be used for with other perpetrators. I mean, you're an expert in this area. I probably haven't articulated this as well as I would hope to in front of a, panel of judges, but how would you respond to that?
No, I think that's a very good point because when you also think about, so I know we both, I'm sure in the adult context as well as the child context, you do see this sort of escalation of behavior, right? And certainly studies have shown that, viewing of child sexual abuse material often is not enough for an offender, right? They will want to gain access to a child. They will want more and different kinds of extreme videos or images to be taken or shared. And then think about the experience of generative artificial intelligence, where you no longer actually need access to a child. You don't have to know any children to create child sexual abuse material using GAI. So now the access component and the fear of getting caught and kind of the requirement to lure or entice a child into that abuse, all of that now has been satisfied by GAI because it's you and your computer. And, it also, being able to create those images, again, of adults and children, maybe very different offender types, of course, doing both, it robs you of some of the basic, I think, human impulse or dignity not to involve yourself in exploitation of incredibly extreme behavior. You no longer have to fear, have I gone too far? You no longer have to hear the victim, see the victim. You no longer have to get over that interaction that obviously offenders do every day, both for adults and for children. Now you can simply keep creating, keep pushing the envelope, changing what you're seeing, trying something out in ways that you simply couldn't with a human being in front of you. So I think those two factors of GAI, again, just by virtue of that they're a technology tool online, increase the isolation and increase the depravity of what somebody could try to see or create with that technology.
100%. And then taking that and trying it out IRL is, just another natural step in the progression. So, Yiota, I said we're going to have you back, and you're probably like, please don't bring me back because you made me work for basically an hour, but there's so much here. And I cannot tell you how beautifully you wove it together. I think, to help people understand the actual harms of these cases, what's involved in these cases, what the law has looked like and is moving towards in addressing child sexual abuse material, and then what it might look like for adult sexual abuse material. So you are, like I said in the beginning, just a real hero of mine, a definite champion, which I think the world needs many more of. And so I like to end these podcasts with 3 quick questions. That's okay. Rapid fire. So I know your work is outside of the courtroom, but what's the hardest lesson you've learned doing your work, maybe testifying in front of Congress or trying to move forward legislation?
I think one of the hardest things when you're, probably for everybody working at NCMEC, is prioritizing. There are so many issues we see. There are so many crimes against children, again, ever evolving, ever global, ever becoming more technologically sophisticated. And I think it's an issue of how do we prioritize where we put our time and effort? Where can we make the most impact for the most children?
And Yiota, I know you didn't start your career working on this, but I am so grateful that you moved into this field of work and that we have you. What would you tell young Yiota about this work, the work that you've gotten into?
That the job of your life is still out there. I often say I'm the luckiest lawyer in the world, that I get to do this work, that I get to work with the people that I do on the mission that is NCMEC, and to help as many children as we all do collectively here.
I love that. And what keeps you coming back to the work even when it's tough?
So as a lawyer, the unexpected nature of developments, the ever-evolving nature, and we just talked about some of these issues that are evolving every day, every case. So for me, it's the unpredictable nature of the work.
Well, I think, not to be corny again, but I think that the future is definitely stronger and definitely a lot more solid because of you and your team working towards a better, safer future for victims, for all victims, for children. And then again, your generosity and your willingness to get on the phone with me whenever I call to talk through the impacts to adults. I'm so grateful. So thank you so much for all you do.
Yeah. Thank you, Jennifer. Thanks for having me. And thanks for letting me talk about some of the NCMEC programs and some of the work we do.
Hey again, folks, Jennifer here. That was such a fantastic conversation. And I mentioned several times that I want to bring Yiota back for season 3. And it's not just because she's a fantastic guest, which she is. It's also because there was very important legislation that was recently passed that's very topical for this discussion. So on May 19th, 2025, President Donald J. Trump signed the Take It Down Act. And while I'm not going to get into the details of this comprehensive new law right now, I do want to flag that it provides prosecutors with important tools for addressing child sexual abuse material and image-based sexual abuse of adults by covering both authentic images and deepfakes. But I will say, make sure you follow and subscribe to the Just Champions podcast so that you're alerted to when season 3 drops this fall and you can come back for the continuation of our discussion where we'll be focused on the Take It Down Act. All right, we'll be back in the fall, folks. And while you wait for us to come back, this is a great time to go back and catch up on any episodes you might have missed in this season or season 1. See you soon. This podcast discusses the violent crimes of sexual violence, domestic violence, stalking, and human trafficking. If you need support, please check the show notes for links to hotlines and agencies that can help. For more information about Equitas, please go to equitasresource.org. That's AEQUITAS resource.org, or follow us at Equitas_resource on Instagram. This series is executive produced by Jennifer Long, Equitas, and Robin Hopkins. This series is sound designed and edited by Dan Kroll. This season of Just Champions is funded by a generous grant from the U.S. Department of Justice Office on Violence Against Women, supporting efforts to improve justice in cases of sexual violence, intimate partner violence, stalking, and human trafficking. The opinions, findings, conclusions, and recommendations expressed in this podcast do not necessarily reflect the views of the Department of Justice Office on Violence Against Women.